Prime Minister and Defense Minister Yoav Gallant of Israel. I'm going to come back to that case. I'm sure it's top of mind for many of you, and we will, of course, address it, and we can discuss it in as much detail as you like in the Q&A. But before the declaration on October 9th by Yoav Gallant of the total siege, no food, no water, no fuel, no electricity, the question of the nexus between hunger and conflict was already of undeniable urgency globally. In each of the last 6 to 7 years, close to, and in some years, well over 100 million civilians have suffered crisis or worse levels of acute food insecurity as a result of armed conflict. And whether in Nagorno-Karabakh or Ukraine, Yemen or Syria, Sudan or South Sudan, Myanmar or Ethiopia, or indeed Gaza, the suffering of those civilians is not simply the collateral consequence of fighting. It's the product of choices that belligerents have made about how to conduct their war. Those numbers far outstrip the number of civilians killed or injured by kinetic attack in the context of armed conflict. And so it's perhaps inevitable that demands for accountability and scrutiny of this phenomenon associated with war have grown. Historically, international humanitarian law was not particularly well positioned to heed those calls. It was largely tolerant and indeed in some cases even encouraging of starvation of civilians as a method of warfare. And it's not until the agreement of the additional protocols to the Geneva Conventions in 1977 that we first get a clear codified prohibition of starvation of civilians as a method of warfare and associated rules relating to objects indispensable to civilian survival and humanitarian access. But even then, it wasn't included in the grave breaches regime, in other words, the criminalization regime within Additional Protocol 1. And so it was not for another 20 years until 1998 in the agreement of the International Criminal Court Statute that we first have an international instrument that identifies starvation of civilians as a method of warfare as a war crime. But we have yet to see an international prosecution of this crime. And so in that jurisprudential vacuum, notwithstanding clarity regarding the prohibited nature of starvation of civilians as a method of warfare and its criminal nature, we have debate, inevitably in a jurisprudential vacuum of that kind, regarding what exactly this means, what precisely is prohibited, at what point does criminal liability attach. At one extreme end of that debate, a claim is made that the prohibition only attaches to methods that specifically seek to cause and weaponize civilians being in a fatal or near-fatal state of malnutrition. I disagree with that view. On my view and the view of others, this prohibition attaches also to methods of warfare that are virtually certain to cause starvation, whether or not that's the goal, and also to methods of warfare that purposefully deny sustenance, whether civilians being in an end state of starvation is certain or even sought as a result of that practice. Concretely, what this means is, on a narrow view, if you have an encircled population that includes combatants and civilians, and that population is cut off from the supply of essentials, the crime doesn't attach if the purpose of that cutting off is to squeeze the combatants in that population. That's the narrow view. The crime doesn't attach because the purpose is to coerce the combatants. And so the civilian harm is to be addressed through precautions and proportionality, concepts that ordinarily apply to collateral damage. On my view, again, that's incorrect. The question is, why is it incorrect, and how do we understand what this prohibition is? And there are two levels on which the disagreement between those who hold that view and those, including me, who hold an alternative view, operate. One is really in the technicalities of textual interpretation. What exactly does starvation mean? What is a method of warfare? What does it mean to say that starvation as a method of warfare is used intentionally? And I'll come back to those more textualist doctrinal debates. But underlying those debates is something more fundamental, which is an underlying normative debate about what really is at stake here, and how does it relate to the principles of international humanitarian law and the regulation of armed conflict more generally. And so I want to start with that deeper normative debate, and within that, begin with an articulation of the normative account with which I disagree, to try and understand exactly what that argument is and then respond to it. So ordinarily, That argument is actually not fully fleshed out in detail. People just assert this interpretation, and you have to read between the lines to understand normatively how can they possibly hold that position. But where it is articulated, and certainly to the extent one can read between the lines where it's not, it seems to rely fundamentally on the concept of military necessity. Those of you who've been studying international humanitarian law, this will be familiar. For any of you who have not, this is probably more aptly translated to military efficacy. It's not really a strict necessity concept, it's more about military efficacy. And the argument goes something like this. When you have a defended locality that has a population of combatants and civilians, particularly if it's an urban area, it can be very difficult to break down militarily, to achieve the military goal of taking over that objective. One way in which to do that successfully is to cut that area off from the supply of essentials and squeeze combatants into capitulation. So you're cutting the adversary off. But because you don't have control over distribution within the area, the only way to cut the adversary off is to cut the whole area off from the supply of essentials. And because there's a military imperative to do that, because that's militarily efficacious, it must be the case that international humanitarian law allows it, because after all, international humanitarian law is a realist regime responsive to the exigencies of armed conflict. And so, the interpretation of the rule must be that it's only illegal if you're seeking to cause civilian malnutrition and starvation. And as long as your only purpose is to squeeze the combatants, it must be permissible. And everything else can be addressed through proportionality and precautions. And often the argument ends there. The problem is it plainly can't end there, because military necessity, even on the terms of international humanitarian law, never operates in isolation. It operates in constant tension with the countervailing underlying principle of international humanitarian law, humanity. And the product of that tension is often bright-line, clear prohibitions which are not subject to further military necessity or efficacy caveat or reinterpretation. For example, it's straightforwardly prohibited to target civilians in a kinetic attack. It doesn't matter if you might achieve a military objective by doing so, and clearly in some cases you can. But you're not allowed to do it because there's a core bright-line prohibition against doing it, regardless of military imperative. You can't engage in torture. You can't kill prisoners of war. All of these rules apply without reference to whether in a particular moment there's a military imperative. So for example, I think, when's there a military imperative to kill prisoners of war? Well, you capture prisoners behind enemy lines, and at that point it's going to be very difficult to bring them back to your side without jeopardy, and releasing them will cause some jeopardy because it might expose your position. You still can't execute them. Your choice is release them or take them. Both of them are going to engage some risk. There's some military advantage to not doing either, but you still can't execute them because there's a bright-line rule against executing prisoners of war. Same thing with attacking civilians. And most pertinently for us, if we take exactly the same civilian population, the same population of civilians and combatants that's in that encircled zone, that we have in mind when we're thinking about the encirclement deprivation, cutting them off from supplies, it is straightforwardly unlawful, a clear war crime and indeed a crime against humanity, to carpet bomb that population as a whole, even if you say, well, the only thing we're trying to do is kill the combatants within that population, and it's difficult to figure out where they are, they're intermingled, we're just going to kill everybody. Our only purpose is to kill the combatants. That's not a defense. It's a straightforward war crime. It's an indiscriminate attack, clearly identified in Article 51(4)A of Additional Protocol 1 and in the jurisprudence of the International Criminal Tribunals as a war crime. But more fundamentally, it's an attack directed at a civilian population, because under Article 50, Paragraph 3 of Additional Protocol 1, a civilian population does not lose its civilian character in virtue of the presence of combatants within it. So if you have a predominantly civilian population, the fact that there are combatants within it doesn't change the nature of the population. So directing an attack on a civilian population constitutes the most straightforward war crime, attacking a civilian population, and that is, of course, also the basis of crimes against humanity, a widespread or systematic attack on a civilian population, which in the context of a carpet bombing campaign of that population as a whole, would clearly implicate multiple crimes against humanity, murder, extermination, inhumane acts, and so on. So then the question is, well, if it's clearly prohibited as a bright line rule without reference to military imperative, to carpet bomb that population, how can it be defended to say you can encircle and deprive that population of essentials? It can't be because we're redescribing the purpose as squeezing the combatants, because we can't make that redescriptive move when we're talking about kinetic attacks. It can't be that it would be militarily effective to encircle and squeeze. It would plainly be militarily effective in terms of taking the objective and neutralizing the adversary to carpet bomb the whole place. But that's not a defense. And it can't be about the difference in the ultimate harm, because pushed to their limit, both of these cause catastrophe to the population. So what then is the defense? What's the justification for treating this kind of case differently and for interpreting a rule that on its face would look as though it prohibits it as permitting it? And the question is sharpened when we recognize that the quote-unquote basic rule of international humanitarian law, codified as such in Article 48 of Additional Protocol 1, is that parties are, in their military operations, not just their kinetic attacks, in their military operations of which it's unambiguous that a siege has to qualify, distinguish between combatants and the civilian population and direct their military operations exclusively at the former. Encircling and depriving a population that is on aggregate civilian, even if there are combatants within it, is not doing that. So then the question is, how can the distinction be drawn? On what basis would one interpret prohibition against this background in a way that says, well, military efficacy demands allowing it? The reason that I think is often either implicit or sometimes explicit in response to that is about time. The claim is that the distinction between the kinetic attack and the encirclement deprivation is that the latter is gradual. In a kinetic attack, the bombs are dropped, people die, people are injured, people are maimed in that moment, and there's no reversing that, there's no adjusting for it. There are, of course, reverberating effects that endure beyond that moment, but many of those are locked in at the moment of the attack. But those who defend the claim of a limited prohibition here argue the encirclement deprivation is different because you can cut off supplies. Nobody starves that day. It takes time for the momentum of starvation to build. And in that time, they would argue, there's a possibility for harm mitigation. There's a possibility for not realizing the ultimate consequence of this particular practice. Most obviously, capitulation, but also through civilian flight from the besieged area. And so the fact of the possibility of that mitigation, they would argue, might allow for a redescription of the purpose as engaging in this practice in order to secure capitulation before anybody is actually starving. Now, to me, that line of reasoning looks very similar to lines of reasoning that are sometimes invoked in defense of torture. And those kinds of arguments look something like this. You're probably familiar with the ticking bomb example. And the claim is basically, if we can use lethal force defensively, when we think that, when we have reason to believe, when it's reasonable to believe there's an unjustified threat to us or somebody else, then why could we not use some method of eliciting information where we reasonably believe that the person has that information and the information could secure the diffusion of a particular threat? Particularly since they can capitulate and give the information. Now, there are many arguments against this, and I'm sure you're familiar with many of them. Torture doesn't work. The ticking bomb case is an artificial case that doesn't actually exist in reality. And even if it did, opening the door to a permission there would have a slippery slope effect that would blow the lid off any prohibition on torture in other circumstances. And similarly, with respect to the notion that encirclement deprivation could be justified with reference to achieving capitulation before starvation, one could respond, it never works until people are actually starving. Moreover, we know that in that context, the people with the guns are going to be the last to starve, and so the notion that we're squeezing the combatants rather than the civilians doesn't actually make sense. And scholars of famine, most notably my colleague Alex Deval, have emphasized you cannot calibrate the impact of starvation with the kind of precision that this notion of moving it up to the point of capitulation and then pulling back suggests. He describes it as like a fast-moving and very heavy freight train. The driver can slam the brakes. It's going to take miles for that thing to stop. You can open the humanitarian floodgates, but once the momentum of famine has taken hold, it's going to take a long time to bring down excess mortality. That is the result of those conditions. And I think all of these are persuasive responses. But I also think there's a sense in which they concede too much, because the wrongfulness of torture isn't just about whether it works or not. And indeed, the wrongfulness of starvation methods, in my view, is not just about the conditions under which they may or may not work. There's also, those are of course important arguments, but they're not the totality of the arguments. There is also something that's more fundamental about the wrongfulness of these kinds of practices. And in the context of torture, I think this is aptly articulated and identified by those who have framed torture as really about tearing our biological imperative to be free from pain and suffering against ourselves, our capacity for higher order commitments, whether those are commitments to a community, to a social group, to our loved ones, to our family, whatever commitments we might have that might cause us to resist a particular demand. The point of torture is to tear our imperative to be free from pain and suffering against our capacity to even sustain that commitment, even those commitments for which we would in principle sacrifice everything. And that, of course, works by torture not just being an escalation of the costs of sustaining that commitment, such that we can tell them, well, at what point is the cost too great? It's about inflicting a pain or suffering that becomes the victim's whole world, that displaces and crowds out the capacity to even think about it in those terms. And in that sense, it's uniquely destructive of our human dignity. It's uniquely attacking of our human dignity, because it goes to one of the most fundamental human capacities, the capacities to make high-order commitments for which we would sacrifice everything. In my view, that identifies a human dignity core that is, of course, powerfully and importantly supplemented by more consequentialist, pragmatic arguments about the fact that torture doesn't work, there are institutional slippery slopes, the ticking bomb case is an artificial case, and so on. But it provides a core around which those pragmatic arguments function. But it can also illuminate what exactly the core wrong associated with starvation methods is. Because how exactly are starvation methods supposed to lead to this purportedly palliated or mitigated outcome where there's civilian flight or capitulation? Well, the only reason that they are supposed to work is through breaking the will of the population that's affected. In other words, by amplifying gradually the pain and suffering to the point at which it's no longer possible to sustain these kinds of commitments. And even when the perpetrator of this kind of action, the besieging party, doesn't seek to do this to civilians, they really just want to do it to combatants, there's no way to get to the combatants except through the civilian population, as I already mentioned, because the people with the guns are never going to be the last to start. And even if there's no real intent to have any view on how you're distorting the human dignity of civilians, what scholars of famine have repeatedly shown is that in these conditions, that kind of torturous effect takes hold. Social bonds break, they rupture. The so-called accordion effect of the web of moral concern contracting amid the desperation to be free from hunger and suffering tears families apart, tears societies apart, tears communities apart in a way that is fundamentally torturous, that is going directly to the capacity for higher order commitments, crowding them out through this distinctively horrific experience. And that reverberates for generations in terms of its impact on a society. But seen in that way, the graduality of starvation methods, rather than palliating as compared to the instantaneous nature of a kinetic attack, in fact is constitutive of the peculiarly torturous wrong associated with starvation methods. This kind of effect can't take place instantaneously. It happens precisely because there's a gradual escalation of suffering. And so, in that sense, normatively, it's not particularly persuasive to look at this and say, well, the graduality makes it more permissive. The graduality instead identifies this alongside probably the clearest, brightest line prohibition we have in international law, namely the prohibition of torture. But of course, everything I've said so far is just about the normative underpinnings. You might say, okay, so maybe morally there's a persuasive case to be made for why siege starvation, supplement starvation is something that ought to have a bright line rule, but does that mean it actually has a bright line rule? What does the law say about it? It's certainly correct to say it doesn't dispose of that question, but I think it does, in the first instance, shift our normative premise in that discussion, and it also shifts the interpretive burden with respect to textual ambiguity. But now let's turn to the text and think about exactly what these rules mean. The first thing to emphasize in this regard are 2 points that I've already made, namely, one, that the basic rule of international humanitarian law, Article 48 of Additional Protocol 1, is to distinguish between civilian population and combatants in all military operations, not just in kinetic attacks. And a siege would presumptively be in that category. And two, that a civilian population retains its civilian character notwithstanding the presence of combatants within it, so it's not possible to dismiss the fact that the target of an operation is a civilian population with reference to the fact that there are combatants within that population. But what then about the specifics relating to starvation? The first thing to emphasize here is the framework that protects objects indispensable to civilian survival, because this, in my view, is really the bedrock legally of how this prohibition works. So ordinarily, as many of you are probably aware, if we take an object that serves a civilian and a military function, so-called dual-use object, most international humanitarian lawyers interpret that as a lawful military objective. In other words, you can target that object under Article 52 of Additional Protocol 1, and the civilian value of the object is protected instead by precautions and proportionality. Precautions meaning that you have to minimize as much as possible the civilian harm associated with attacking, and proportionality meaning you can't attack it at all if the civilian harm, injury, death, damage to civilian objects expected from that attack would be excessive in relation to the concrete and direct military advantage anticipated. Those are, of course, important protections layered onto this issue of dual-use objects, but they're highly fact-specific, context-contingent, and then, for that reason, often disputed in concrete cases. What exactly could have been done more to minimize civilian loss? How do we weigh exactly the civilian damage here versus the military advantage, and so on? So it's critically important that objects indispensable to survival, a category within international humanitarian law that most obviously includes food and water systems, but also other kinds of objects that are indispensable to survival, are subject to a different regime. They're not subject to that dual-use object regime. They're subject to a clearer and more stringent set of prohibitions. We can see this in Article 54 of Additional Protocol 1, particularly paragraphs 2 and 3. There are two key upshots to something being an object indispensable to survival that distinguish it from how we think about objects in international humanitarian law generally. The first, and this is in 54.2 and 3a, is that it is prohibited, straightforwardly, to attack, destroy, remove, or render useless an object indispensable for survival for the purpose of denying its sustenance value, including denying its sustenance value to combatants, unless combatants are the only people who draw sustenance from that object. Put more simply, unlike dual-use objects generally, dual-use sustenance is not targetable. It's protected, and it's protected before we get to questions of precautions and proportionality. In other words, before we think about, well, what more could have been done to limit civilian harm, or how heavy was the civilian harm versus the military advantage, this is before we get to that point. It's a bright line, you can't do it. If any civilians are drawing sustenance from that thing, and you're destroying it, attacking it, removing it, or rendering it useless, for the purpose of denying sustenance value, that's prohibited, straightforwardly. The second rule is, and this is in 54.3b, even if you're attacking, destroying, removing, or rendering it useless for reasons other than its sustenance value, perform some other military function, it's still prohibited to do that if it's known that this will cause civilians to starve or force them to move. And again, this attaches before we get to precautions and proportionality, before we're thinking about that question of what more could have been done to limit civilian harm, how do we weigh military advantage in this context? These are bright lines before we get to that point. Now, this is straightforward for attacking, destroying, removing, and rendering useless. You might think, well, doesn't that just dispose of the whole question? The reason why then some come back and say, well, hang on a sec, that doesn't quite capture encirclement deprivation, because they say, well, that's not attacking, destroying, removing, or rendering useless. That's blocking the supply of indispensable objects, but that's not prohibited under the framework I just laid out. Instead, we need to turn to starvation of civilians as a method of warfare, the umbrella prohibition, and understand what that means. And it might mean something very different from the protection of objects indispensable to survival. Now, there are several problems with that response, one of which is that it's possible to invoke components of the framework that I just mentioned in the context of encirclement deprivation. So one can argue that impeding humanitarian relief to a population for which it's destined is rendering that relief useless to the population for which it's destined. So it would fall straightforwardly under the category I just mentioned. And if you say, well, but hang on, it could be given to somebody else, so it's not completely rendered useless in the way that, say, poisoning a water system would render that water system useless. Well, if it's taken from the humanitarian mission and given to somebody else, it's removed. So we're back into one of the categories: attack, remove, destroy, or render useless. But even if one thought, well, that's a little bit of a stretch, and maybe there are ways in which impeding humanitarian relief wouldn't quite fall into either of those categories, particularly if one goes back to the drafting history and says rendering useless was really thought about in terms of poisoning wells and so on, then the question is, okay, but we all agree starvation of civilians as a method of warfare applies. So then the question is, what does that mean, and how does it relate to objects indispensable to civilian survival? And the thing is, they're intricately interlinked. They're not just two separate prohibitions. Starvation of civilians as a method of warfare is prohibited in Article 54.1, which is the first paragraph of the article that's entitled The Protection of Objects Indispensable to Survival. Paragraphs 2 and 3 outline the precise framework that I just gave you with respect to the protection of objects indispensable to survival. The ICRC commentary says those are the ordinary development and application of the prohibition in paragraph 1, which makes no sense at all if they apply a completely different and much broader framework than is applicable under paragraph 1. So then the question is, okay, well, what do you mean by starvation of civilians as a method of warfare? Doesn't that just straightforwardly mean seeking to put civilians in a state of starvation and weaponizing that state of starvation? Well, not necessarily, because starvation has transitive and intransitive meanings. In other words, you take a detainee who's well-nourished and lock them up and stop feeding them, you have begun immediately the process of starving them. You are in a practice of starvation. I don't need to use the second person. One is in a practice of starvation in that moment, vis-a-vis that person, even when they're not yet in a state of malnutrition. Starvation is transitive as well as intransitive. So what does that mean when we're thinking about what starvation of civilians as a method of warfare means? It means precisely what 54.2 and 3a say it means, which is if you're intentionally denying sustenance and denying it to a population that includes civilians, you're engaged in starvation of civilians as a method of warfare, transitively, even when that civilian population is not yet in a state of fatal or near-fatal malnutrition, and even when you don't necessarily want it to reach that state because you're trying to achieve something before that. But additionally, starvation does have an intransitive sense, and that's what 54.3b captures, which is that if you engage in deprivation of objects indispensable to civilian survival for other reasons, knowing that civilians are guaranteed to starve as a result, you're also engaged in starvation of civilians as a method of warfare. And these map on, in the criminal law context, to oblique and direct intent. Those are grounded. The first is direct intent, the second is oblique intent. Codified is such in Article 30 of the ICC statute. So what does all of this mean concretely? Well, it means when we're looking at an encirclement deprivation situation, the first question is there the deliberate deprivation of objects indispensable to survival? Are they deliberately being blocked? Second question is the reason they're being blocked for their sustenance value in a context in which the population that's affected includes civilians, and definitely if it's a civilian population in aggregate? If the answer to that is yes, it's clearly prohibited. If the answer to that is no, the next question is it known, even if they're being deprived for some other reason, that civilians will starve as a result of this? If the answer is yes, it's prohibited, and the crime can attach. So now applying this to a specific situation, and particularly the situation in Gaza, since that's a situation that is probably familiar to most people in Rome. Well, let's go back to October 9th and your government's statement. No food, no water, no fuel, no electricity. A total siege. When he declared that they were depriving the population of objects indispensable to survival. That's just undeniable. Food and water are the most obvious forms of objects indispensable to survival. Fuel and electricity in this context are also indispensable to survival in various respects in terms of hospital viability, in terms of desalination plants and so on. But we might get an argument that, well, with those it wasn't for sustenance denial. So let me come back to those in a second. With respect to food and water, declaring that you're cutting off food and water as such, as food and water, just is to engage in purposive sustenance denial, because food and water, as food and water, are nothing except sustenance. So to cut those off is to engage in purposive sustenance denial, and doing it to a population that is unambiguously civilian at the aggregate level. Even by US intelligence estimates, Gaza is 98% civilian. So it's just clearly a civilian population. So directing this kind of practice at that population is purposive sustenance denial vis-a-vis a civilian population. The war crime attached immediately on October 9th. There's just no question about that in my view. Now, it extends clearly for the next 2 weeks before the Rafah crossing is open, but even after that, there's just a trickle coming in. It's 70 days before Kerem Shalom is open. And even then, all humanitarian agencies say there's not nearly enough getting in, and we're getting purposeful denial at the border, failure to deconflict, attacks on agricultural areas, attacks on water systems, attacks on humanitarian distribution centers, and so on. Now, even if, being maximally generous, at the point of the opening of Kerem Shalom, one said, well, there's some debate about whether it's still for a sustenance denial purpose. Well, at that point, it was certain that continuing to do this was putting civilians into a situation of starvation. By December, the Integrated Food Security Phase Classification Report, in relation to northern Gaza, where the siege was tightest, identified 25% of the population being in IPC Phase 5, which is the highest phase, it's the famine phase. It's the point at which there is no food. And we're talking about significant excess mortality. And 65% of the population in northern Gaza has either emergency or catastrophe, the two highest phases, in December. And this then continues through to March, by which point we get 80 and 55% as those numbers in northern Gaza. So even if one looked at that and said, well, can we be sure it was for the purpose of sustenance denial? With which I don't have that much sympathy. But even if one took that view, by that point, it was clear that the consequence of doing this was causing starvation. Oblique intent attaches. This is the second category of intentional starvation of civilians as a method of warfare. Now, in March, things do change somewhat. They change for basically three reasons: that IPC report, the ICJ's second provisional measures order, and the attack on the World Central Kitchen convoy, which significantly changes the way in which the US is seeking to pressure this situation. So we do see more humanitarian access in March and April. And the numbers, therefore, in the June IPC report are actually better than the numbers in the March report. So it's not completely implausible to say that the crime lasted until March and then didn't continue in March and April, again being maximally generous. But then in May, we have the Rafah offensive, and the humanitarian access craters again, so that the access in July is 50% of what the access was in April, and it's back down to levels where we're seeing surging malnutrition. Refugees International recently came out with a report a couple of weeks ago, maybe just a week ago, I can't remember, where they identified continued clear obstruction. The humanitarian organizations are all saying this isn't about Hamas looting it, it's not about Hamas diverting it, this is primarily about IDF obstacles to our delivery. And we have this resurgent malnutrition, and therefore the crime, even if it paused during March and April, comes back in May and continues through to the present. So in my view, on the substance, it's very clear that the International Criminal Court should grant these arrest warrants. That most of the debates, as you probably know, at this point are about jurisdiction and complementarity. We can discuss those. I think they're both bogus objections. So I expect that the ICC will grant this arrest warrant for both Netanyahu and Gallant. And that my hope would then be that this shifts the posture, certainly in states like Germany, that are party to the ICC statute, to say, we have to maximize the pressure here, we have to change this trajectory. But my second hope is that it doesn't just do that with respect to Gaza, but also elevates attention to the fact of this phenomenon across all situations, including, critically in this moment in Sudan, where the conflict between the Rapid Support Forces and the Sudanese Armed Forces has caused a declared famine in Zamzam camp, and also catastrophic food insecurity across multiple regions of Sudan. And of course, the ICC prosecutor in his report to the Security Council earlier this summer said he expected to request arrest warrants in the context of Sudan. Really, at the ICC, it's in the context of Darfur, and so there's some territorial jurisdiction questions that will arise there before the end of the year, so pretty soon. Whether those will include starvation of civilians as a method of warfare is slightly less clear because it goes somewhat to conflict classification issues. But in any event, you can classify these kinds of crimes under crimes against humanity, most obviously inhumane act, but also, as was done in the Israeli arrest warrant request, extermination and murder, as well as additional war crimes. So I'll pause there, and I look forward to engaging with you.
Well, good afternoon. I am Denise Garcia from the College of Social Sciences and Humanities. A class that I always teach that you're welcome to is International Law, the Introduction to International Law. I welcome the presence here of several of my students from the College of Social Sciences. My dear friend, Professor Miller, thank you for having me. What an honor to be here with you, with Professor Dannenbaum. Professor Dannenbaum, what a brilliant, brilliant expose. Very vigorous argument. Indeed, my comments will only add, hopefully, to already the strength of your argumentation. Indeed, the graduality of starvation does not make it more permissive. And we must imagine now, right, what are the bedrocks upon which this prohibition should rest? What is the landscape of law that can underpin the arguments so powerfully presented by Professor Dannenbaum? So let's start with three elements of a preface for us, shall we? To guide us, to underpin our thinking here. Let's take the case of Gaza first. Indeed, Israel as the occupying power already had pre-existing obligations. Therefore, the crime of starvation that just compounds to already the no-observance of their initial duties of protecting that civilian population, perhaps. I just throw up this out there for your thinking, for your legal thinking. The second element is that indeed we can take international humanitarian law as a general, in its general evolution since 1863, since when the International Committee of the Red Cross was created in Geneva, when the very first Geneva Convention was negotiated, and how it evolved since with the 4 Geneva Conventions, the additional protocols. And I was very impressed how Professor Dannenbaum can recite all the pertinent articles by heart. Very impressive indeed. And also the other conventions that would be pertinent here, such as the Convention on Chemical Weapons, the conventions that pertain to the prohibition of certain weapon systems. So we could powerfully argue that the siege starvation violates the two of the core principles of international humanitarian law. One, of course, as you very well argued, is this distinction between civilians and combatants. So it completely nullifies that one. And the second principle that is always guiding international humanitarian law is that an attack must create very little incidental harm to civilians, right? So an attack must be proportional to the intended military target. So in no way we could argue that siege starvation would be abiding by this, would be observing this very important customary principle of international humanitarian law. The third element to guide us here would be that, well, there is a very, very comprehensive political agenda now, a political map, a global map of action that states have just reaffirmed over the weekend at the Summit of the Future, the United Nations, which is to observe the Sustainable Development Goals and to achieve them. Sustainable Development Goal number 2 is indeed zero hunger. And all countries have, except for a handful, including Russia, accompanied by Belarus, North Korea, Nicaragua, Syria, and I think one more, have reaffirmed this goal of zero hunger. So with that in mind, allow me please to perhaps lay out indeed the basis that would add on to Professor Dannenbaum's very powerful argument, where the siege starvation is indeed prohibited under international law. The first one is, of course, I would say as a basis for us, for our thinking here, is the United Nations Security Council resolution. And indeed, that is, was of 2018, adopted unanimously. It was a landmark resolution, 2417, Security Council 2018. Very significant indeed. The use of starvation as civilians as a method of warfare may constitute a war crime. So that, and indeed here, I think that was a very pivotal moment for us to consider siege starvation as a crime. The second basis would be international criminal law. And here we start, of course, with the International Criminal Court Rome Statute, Article 882b, and prohibits the deliberate use of starvation as a tactic of warfare. However, this was initially conceived for international conflicts. The amendment that was adopted later in 2019, just a few months after the Security Council resolution, was indeed the one that criminalizes intentional starvation as a method of warfare in all types of conflicts. And Professor Dannenbaum wrote, I believe, the seminal article that discusses that in the Chicago Journal of International Law, that I would invite all of you to review again. The third basis is all of human rights law. So if we take elements from a lot of the conventions on human rights law, we can strengthen our argument for this as a crime against humanity. So if we can take where is the right to food and the right to be free of hunger codified under international human rights law. We can start with the Convention on the Status of Refugees, Article 20. We can go on again to draw strength from the 1966 Covenant on Economic and Social and Cultural Rights, Article 11, that also says that humans it's a constitutional right to be free from hunger. We can go on to see the Convention on the Elimination of Discrimination Against Women, Article 12.2. We can go on to the Convention on the Rights of Child, Article 24.2. Even the Convention on the Rights of Persons with Disabilities, Article 28. And indeed, we can go even to find solace at the Universal Declaration of Human Rights, also Articles 1, Article 3, Article 5. I read it again and again, and I said which articles can serve as a basis for us. And finally, the very Convention Against Torture, 1984, and Professor Dannenbaum already gave us all the elements for that. Finally, international humanitarian law would be our fourth basis, the clear codification of the prohibition, and Professor Dannenbaum already gave us all the essential elements for that. I end my comments by saying international law has been undergoing through a process of humanization of international law. Therefore, the prohibition of siege starvation will only find indeed a principal basis in this process, evolution of international law, as a humanized legal code for all humanity. Thank you indeed, Professor Dannenbaum. It's a pleasure being here with you today. Thank you.